Ladies and gentlemen, if I may have your attention for a few seconds, I'd like to welcome you tonight. Thank you for coming. I imagine it was a busy day, so once again, it's been a pleasure. And my only duty tonight is to introduce Mr. Matthew Hudson from Overy, because he's going to be the chair tonight, and he's going to take care of introducing the panel. So please give it up for Matthew Hudson.
I think it works, yeah. Yeah, seems to. So good evening, everyone, and sorry to have kept you waiting a little while, but we're here now, finally, and I'm very pleased to introduce to you a very distinguished panel that I've got the pleasure of being joined by. So starting from the far left, we have Dr. Li Hu, who is the Deputy Director of CTAC. As well as being the author of innumerable publications, which I was perusing and was fatigued just by looking at on my way over. We then have Mr. Tim Meng, who is the managing partner of Golden Gate Lawyers, and he is primarily an arbitration practitioner who has sat as arbitrator and been counsel in a very large number of disputes. And last but by no means least, we have Mr. Rostislav Pekash, who is based here in Prague from Squire Sanders, where he is a partner and is a prolific arbitration community figure, both in the commercial arbitration arena and in investment treaty cases. So I am really delighted to have such distinguished panelists. And I also should mention that in the audience we are joined by Dr. Vít Horacek, who would be sitting with us were there space, but has kindly volunteered to contribute from the audience instead. Just before I pass you on to these speakers, by way of brief introduction to the topic, this panel is, of course, about enforcement of arbitration awards, the sort of business end, if you will, of what we do as arbitration practitioners. And it's a topic which is, it shouldn't need reminding to anyone, but it's a topic which is of great importance and is often, I think, somewhat overlooked at conferences and in discussions such as this. So I congratulate the organisers for focusing on it. And of course, the starting point for any discussion of enforcement is an instrument that I'm sure many of you are aware of, the New York Convention of 1958, which is perhaps the most successful private international law instrument ever concluded, and which now, I believe, as of a month ago, with the addition of Burundi in June, has 150 member states who have now ratified. So the New York Convention, as well as obliging states and the courts of those states to recognize arbitration agreements and to defer to those agreements and not to entertain disputes before the courts in breach of those agreements, also obliges states under Article 3 to enforce those agreements, subject to the exhaustive list of exceptions in Article 5. So that is the starting point for all of this discussion and just the brief context, but I'll now invite the speakers in turn to add to that. And I think in particular our speakers from China will be addressing, unsurprisingly, aspects which are more particular to the enforcement regime there. And Mr. Pekash will then go on to discuss some of the more sort of practical issues that often come up with enforcement of awards. So with no further ado, I'd invite Dr. Li Hu to take the floor.
Well, good evening, ladies and gentlemen. Actually, my colleague and I are very happy to be invited to this Prague Summer School events so that we can have this opportunity to discuss some questions in connection with arbitration. Introduced by the moderator, the topic for the panel discussion is enforcement of foreign arbitration award. So the enforcement is an important issue in the arbitration field. Mr. Meng and I will introduce the enforcement of foreign arbitration award in pure China. So I will give the general picture of enforcement and also give some comments of some specific cases, followed by Ms. Wen's specific introduction about practical issues concerning enforcement of foreign arbitration award in China. The legal framework for arbitration in China. In China, the legal framework within which arbitration is conducted consists of following: the law, the judicial interpretations, and certain international treaties. The first is laws. As you may know that in China, National People's Congress is the legislature. So the laws adopted by NPC or its standing committee include the laws. The most important laws in connection with arbitration consist of following: the first is the arbitration law, which was enacted in 1995, 1994, and came into force in 1995 in China. The second, civil procedure law, 1991, and the law was updated once again last year. The other important law in connection with arbitration is the contract law in 1999. The second is judicial interpretation. As you may know that in China, we have 4 levels of court: Low People's Court, LPC; Intermediate People's Court, IPC; High People's Court, HPC; and Supreme People's Court, SPC. In practice, in accordance with Chinese law, SPC is invested with the power to issue interpretations concerning questions with regard to the enforcement application of law. SPC's judicial interpretations have legally binding force over different levels of people's courts. Therefore, SPC's judicial interpretations are playing an important role in law enforcement in China. Therefore, arbitration law and the civil procedure law must always be read in conjunction with SPC's judicial interpretations. Since the enactment of the arbitration law in 1994, SPC has issued more than 30 instances of judicial interpretations. Last is international treaties. The most important international treaties in connection with arbitration ratified by China is New York Convention. Another one is Washington Convention. China ratified New York Convention in 1986. Then convention came into force in China in 1987. Another important convention is the Washington Convention. As you may know that it's about the settlement of the investment disputes. China ratified the Washington Convention in 1992, and the convention came into force in China in 1993. So the general picture for enforcement in China. In China, with regards to enforcement, it may be said we have 4-pronged enforcement mechanisms: one for domestic arbitration award, one for foreign-related arbitration award, one for foreign arbitration award, one for award from Hong Kong, Macau, and Taiwan region. The question is, what's the difference between domestic arbitration award and foreign-related arbitration award? So in practice, the dividing line between domestic arbitration and foreign-related arbitration is that the foreign-related arbitration involves with foreign elements. So that question is, how to define foreign elements? In accordance with Chinese law, foreign elements mean one of the following. The first one, neither party is Chinese. The second, legal facts that initiate, modify, or terminate the legal relationship between parties take place in a foreign country. The last one is that subject matter is situated outside China. Therefore, if arbitration is related to one of the foreign elements, it should be a foreign-related arbitration. The difference between the mechanisms for enforcement for mechanism for domestic arbitration award and foreign-related arbitration award is that for domestic arbitration award enforcement procedure, the court may review the merits of the award. For example, if the main evidence on which the award was forged, on this ground, the court may decide to refuse enforcement of the domestic award. However, for foreign-related arbitration award, the court only has the power to review procedural matters. Such matters are set out by the law. It's a limited ground for refusal. For the foreign arbitration award, in China, the enforcement is mainly conducted in accordance with the New York Convention of 1958. We also have mutual arrangement between mainland China and Hong Kong SAR and Macau SAR about the mutual enforcement of the arbitration award in Hong Kong or Hong Kong award in mainland China. If I remember rightly, it should be in 1999. The SPC and the Hong Kong SAR has signed a mutual arrangement about the mutual enforcement of the arbitration award. In 2007, signed the arrangement of mutual enforcement of arbitration award with the Macau SAR. With other questions was in connection with the Taiwan award. The question is a little bit special. In Taiwan, if I remember rightly, there's special law containing provisions about the enforcement of mainland judgment in Taiwan. It also applies to enforcement of mainland award in Taiwan. In 1998, SPC issued judicial interpretations about enforcement of the Taiwan judgment in mainland. This judicial interpretation also applies to enforcement of Taiwan award in mainland China. Actually, Taiwan award has been recognized and enforced in mainland China. So there should be no problem about enforcement of Taiwan award in mainland China. Well, how about legal framework for enforcement of foreign award? The first national law provision. We know that Article 283 of Civil Procedure Law is about the enforcement of the foreign award in pure China. In accordance with this provision, if they are applicable international treaties or other multilateral bilateral agreements between China and the country where the award was made, so enforcement of foreign award will be conducted in accordance with such international treaties or agreements. In the absence of the applicable international treaty or other agreements, the enforcement will be conducted in accordance with the principle of reciprocity. As mentioned before, New York Convention ratified by China is most important invention for enforcement of foreign arbitration award in pure China. The third one is SPC's judicial interpretations. SPC's judicial interpretations concerning enforcement of foreign arbitration award in pure China includes the first SPC notice on the implementation of the New York Convention in 1987. The second SPC notice on several questions about courts handling the issues related to foreign-related arbitration and foreign arbitration in 1995. By this judicial interpretation, China SPC has established what's called pre-reporting system, which will be introduced by Mr. Meng later. A third one is SPC regulation on questions about fee charge and the time limit for examination in relation to regulation and enforcement of foreign arbitration award. It's about the fee charge and the time limit. The last one is SPC regulation on several issues about the jurisdiction over foreign-related civil and commercial actions. It's about the competent court for enforcement of the foreign arbitration award in Imperial China, which will also be introduced by Mr. Meng later. As mentioned before, in China, the enforcement of foreign award in China is mainly conducted in accordance with New York Convention. Another convention ratified by China is the Washington Convention. As you may know that, Washington Convention is about investment arbitration. By that convention, the convention established regime for independent enforcement of investment award. In 1987, SPC issued notice on implementation of New York Convention. SPC notice on NYC in practice equals to implementing legislation in China. When China ratified the New York Convention and made two reservations. One is reciprocity reservation, one is commercial reservation. By the notice on New York Convention, the notice directly referring to the text of the New York Convention. So China adopts the enforcement regime envisaged by New York Convention. The next issue is about enforcement under the UNSC. How about the application by Chinese courts of the grounds for refusals? As we know, in accordance with Article V1A of the New York Convention, invalid arbitration clause or no arbitration agreement between parties constitutes grounds for refusal. However, how to decide the invalidity of the arbitration clause in accordance with Article V1A of the New York Convention? The parties may choose the law applicable to the arbitration agreement. In the absence of the agreement, the applicable law should be the law of the country where arbitration takes place. So the first case, the case one, the Repower Limited versus Shanghai Far East Area Technology Import-Export Corporation. In this case, the parties in the arbitration clause of the contract agree that arbitration should take place in Stockholm. Arbitration Institute of Stockholm Chamber of Commerce has accepted the case, and the tribunal has made a decision that the tribunal has jurisdiction over the case. However, the Chinese party initiated court litigation at Shanghai Intermediate People's Court. The court also accepted the case and make order that the court has jurisdiction over the case. Why? Because in accordance with the provision of Chinese law, the arbitration agreement is invalid. Because the arbitration clause didn't nominate the arbitration institution. As we know, in accordance with the provision of Chinese arbitration law, valid arbitration agreement must contain the specific arbitration institution. Otherwise, the arbitration agreement is invalid in China. That means that ad hoc arbitration is not allowed in mainland China. So the question is, what's the law applicable to the arbitration agreement in this case? In accordance with New York Convention, the law should be Swedish law. It's not Chinese law. So the court wrongly use the Chinese law to decide the validity of the arbitration agreement is not correct. Case 2 is about the S&H Foodstuff Trading Company versus Xiamen Lianfa. In this case, the parties in the contract agreed that arbitration should be submitted to Hamburg Exchange Commodity Association. The place of arbitration should be in Hamburg of Germany. So the court rightly ordered that the arbitration agreement is valid in accordance with German law because the place of arbitration is Hamburg. So the court did the right thing. Another ground for refusal under New York Convention is irregularity in arbitration procedure. Also, the parties can agree the law applicable to arbitration. In the absence of the agreement, the law applicable to arbitration should be the law of the country where the arbitration takes place. That means that arbitration place decides the law applicable to the arbitration. This is the uniform conflicting rules confirmed by the New York Convention. In case 1, Dalian Ocean Transportation versus Texel. The arbitration agreement in this case is ad hoc arbitration in UK, in United Kingdom. The court rightly held that the arbitration agreement is valid in accordance with the English law, so the word should be enforced and dismissed the respondent's application for non-enforcement of the word in the court. However, case 2 is about a word from Singapore International Arbitration Award. The new case of last year. The award has been refused enforcement by Chinese courts. Why? The case is a little bit special. In the arbitration agreement, the parties agree that the disputes should be submitted to Singapore International Arbitration Court, International Arbitration Center for arbitration, but SCC arbitration rules should be applied to arbitration. So the claimant initiated arbitration proceedings. The proceedings is conducted in accordance with SCC arbitration rules. There should be no problem. However, the appointment of the arbitrator and the formation of the tribunal is not in accordance with SCC rules, but in accordance with arbitration rules of Singapore International Arbitration Center. So after final word has been made, and the losing party and the winning party sought enforcement of the word to Chinese courts, and another party claims that the word should be refused enforcement because the procedure for appointment of the arbitrator and the formation of the tribunal is not in accordance with the agreement parties. That means that it's not in accordance with the SCC rules. The parties don't agree that Singapore International Arbitration rules should be applied to the appointment of the arbitrator and the formation of the tribunal. Chinese courts finally decided to refuse enforcement of this award. Under the New York Convention, another ground is about public policy. In case 1, it's about Guangdong Ocean Shipping Corporation versus Marships. This is an ad hoc arbitration by 2-member tribunal in London. It's a maritime case. The winning party sought enforcement award to Dalian Maritime Court. The court rightly held that although in accordance with provision of Chinese arbitration law, ad hoc arbitration is not allowed. However, the ad hoc arbitration agreement is valid in accordance with the applicable law, English law. The award does not violate the social and public interest of China, so the award should be enforced in China. So the award is enforced in China successfully. However, the case 2 is about the SEC award. It refused enforcement by Chinese courts. The award is also a little bit special. In the award, the tribunal decides a matter which has been finally decided by Chinese court. So the competent Chinese court has that the tribunal is in excess of its authority and made decision with regard to the issue which has been finally decided by Chinese courts. So the word violates the conflicts with the Chinese basic judicial system. That's that Chinese courts thought the tribunal has no right to deny Chinese judicial system. So the court thinks that the award violates public policy of China and decided to refuse enforcement award. I personally think that the Chinese court's decision is worth discussion. Why? One matter has been decided by Chinese courts. This part of the world may be refused enforcement, and the rest of the world should be enforced in China. So, by my presentation, I want to say China has established solid legal basis for enforcement and a very supportive court intervention. However, application by Chinese courts of the grounds for refusals under New York Convention is a little bit strict. So that's my presentation. Thank you.
If anyone has questions now, please do raise your hand.
I would have a question concerning the second case on the public policy.
Yes.
Is it known whether the arbitrators knew about the existence of the Chinese judgment? Has it been
Yes, because one party submits the judgments to the tribunal. Yeah. Please.
You have mentioned about the enforcement under the New York Convention, and also mentioned about the application by Chinese court. Is this Chinese court, including the Hong Kong, for example, the CTAC? If it's the CTAC rules is different from the mainland, the Chinese court in the mainland.
I refer to the court in mainland China, not including the Hong Kong court.
So what is the application under the New York Convention for the foreign arbitration award in Hong Kong?
Well, enforcement of the, Hong Kong is part of China. It should be no problem for foreign award enforced in Hong Kong. Of course, it should be conducted in accordance with New York Convention. Enforcement of Hong Kong award in mainland China, and enforcement of mainland China in Hong Kong is as per the arrangement between Hong Kong and mainland China.
Excuse me, I have one question. I want to know whether the New York Convention is binding to all of the arbitration cases, because if the parties, according to the parties' autonomy, they choose another applicable law, whether it's binding to the New York Convention, whether the New York Convention will be applicable.
Could you please repeat the question once again? You mean the parties choose?
Parties choose their applicable law. Yes, China implemented the New York Convention as part of the law. So, is it the New York Convention is the law that must be complied with, or you can choose it according to the parties' autonomy?
You know, New York Convention is about enforcement of foreign arbitration word. It's concerned enforcement of the word. Of course, according to party autonomy, the parties are free to choose a law applicable to arbitration, applicable to arbitration agreement, even can choose a law applicable to the substance of the case. It doesn't matter. You know, by referring to the text of the New York Convention, we adopt the enforcement regime envisaged by the New York Convention. We don't transfer the New York Convention into the Chinese law provisions.
Okay, so move to is I just want to ask in another way, because sometimes the arbitration clause, the parties can decide how to use their applicable law, but I just want to know that whether the New York Convention always apply to this kind of disputes or the cases.
Yes. As I introduced before, when ratified the New York Convention, China has made a reciprocity reservation. That means that, for example, if a word was made by the tribunal in the country which didn't ratify the New York Convention, China will not enforce a word, foreign word, in accordance with the New York Convention. The word only be enforced in China in accordance with the principle of reciprocity. Yeah.
Excuse me. Okay.
Oh, please.
Yes. I want to know that how can we identify the public policy? I know that if the arbitral word was in conflict with the public policy, there will be a rise of this enforcement. But how can we identify this public policy? Maybe the content match with some international convention. Maybe we can identify this regulation as public policy.
Your question is a good question. As I know, in our panel, we have a speaker to address the public policy issue. Maybe a speaker will answer your question later, okay? Please.
You mentioned that there's this case that the arbitration agreement is not in compliance with the Chinese law, however, it's in compliance with the law in the seat of the tribunal. So the Chinese court refused to enforce this award simply just because the arbitration agreement is not in compliance with the law in China. Can the Chinese court do that, or my question is that whether the arbitration agreement has to be in compliance with the law in the which the parties choose, or and also in compliance with the law of the place of enforcement.
In accordance with the judicial interpretations of SPC, the parties in arbitration, the parties have the right to choose a law applicable to arbitration agreement. So the validity of the arbitration agreement should be decided in accordance with law applicable to the arbitration agreement as chosen by the parties. I know the question is that you care the law of the place of the arbitration, whether or not such law should be applied to the arbitration agreement, right?
Can I help you out? Yeah, can I help you answer the question?
Please,
So the question pretty complex. So we have two laws. So whenever we talk about governing law, international law, we talk about two. The first one are three. So the first is the governing law of the contract. The second law is the law governing the procedure. But New York Convention is not either of the two. So New York Convention is about the country how to recognize and enforce the arbitration award. Beyond that, this is beyond. This is not based on any party's consent. No, this is a separate issue. So go back to this question. So the arbitration agreement, generally speaking, is separate to the contract. So we believe the arbitration agreement can stand alone to a agreement. So the question is how, based on which law you judge, you evaluate the validity of arbitration agreement. So we have a couple of choices. The first one is, do you have a joint agreement on, we talk about arbitration agreement. So normally you don't. The second, so normally they use the law of the place of arbitration to judge the validity. As all the cases referred by Dr. Lee is they use, so the reason why they don't use Chinese law, don't use the law of the court to judge, to enforce this arbitration is because they believe the law of the place of arbitration should apply in this case. So that's the second law. The first one is based on the mutual agreement. Second is the law of the place of arbitration. The third law would be the law of the court. So where you go to apply to recognize and enforce the arbitration award. So basically, you have three options, basically. So, but the three options is not the equal. So, who shall take the priority based on autonomy, based on the agreement? If you do not have agreement, based on the place of where the arbitration is taken. And third is where the court is located. So the court of where you go to for enforcement. So that is the probably.
If the agreement is valid according to the law in the seat of the tribunal, however, it's not valid under the law of the public.
It's about priority. So like the case judged by the Chinese court, they believe for the validity of arbitration agreement, so we go first to the law of where the arbitration take place. So if you can make a good answer about this question, so we don't necessarily refer to the law of the court where you go to enforcement. And I go back to a question for you. So we talk about the public interest, public policy. So so one of the tribunal member of the panel member will go through this issue. So the two cases we refer here is, so we have, so because we don't have any interpretation in the law what means public interest or public policy. So we have two cases. The first case, I give some indication, is about if a judgment is made based, if the transaction was engaged in violation of Chinese law, this issue does not necessarily constitute a base of conflict to public policy. So even this transaction would be deemed invalid, void, and the Chinese law fine. So if the arbitration recognizes, it's fine. But the second case is more complex. Yes, as far as I understand about the second case, background was like this. There was a joint venture between two parties, one Chinese party and a foreign party. They built up a joint venture. And the joint venture built up a lease agreement with the foreign party. So we have two contracts. One is joint venture contract between Chinese party and foreign party. The other contract is a lease agreement between the joint venture and the Chinese party. So we have two contracts. Because the joint venture, they lease the land from the Chinese landlord, but they fail to pay the royalty or the lease. So the Chinese party sued the joint venture. The joint venture is subsidiary, but they sued this subsidiary, the joint venture, and they go to the court to make a mortgage or some like freezing preservation of the asset. So the Chinese court has already made a judgment based on this issue, but the foreign party. But however, the preservation of the asset has caused a big negative impact to the operation of the joint venture, eventually caused like a termination of the business. So that made the foreign party very angry. So that's why they sue with ICC. So ICC made a very comprehensive but in a judgment in favor, award in favor of the joint venture. So at prima facie, so these are two procedures. One is a Chinese procedure, Chinese court procedure. The other one, the ICC procedure. But as merits of the case, the award made by ICC overruled the Chinese judgment. If we recognize and enforce the arbitration made by ICC, that means automatically, so we will have to overrule the Chinese judgment. So that made the Chinese court very, they become very sensitive. They say if we recognize ICC award, that's a big challenge about the Chinese law authority. So that's why. So that's the background. So if we give up more details about the background, you may understand how that constitute, and the Chinese law constitute a public policy concern. So whenever I give this speech, I will refer to a Hong Kong court case that may help to learn. So what, from the Hong Kong law perspective, so whether, the public, what means a public policy. So I will give some more. Of course, other panel member will illustrate the issue as well.
So the story a little bit complicated.
Yeah, pretty complex.
Thank you. Just, I'm just conscious of time. Perhaps we can take one more question. If you could then save the rest until the end. One final
please.
question.
Okay. Thank you, Dr. Lee. And I have only one question for you. And I want you to comment something because in China the ad hoc arbitration is not permitted, and also the like two member tribunal in London, especially focusing on shipping, is not permitted to. So will China keep the track of pace to the world for this patterns of arbitration has been exist for maybe hundreds of years. It's a trend of the world. So do you think China will follow the world to admit ad hoc arbitration and the two members tribunal?
Well, your question is a good question. I personally think that Chinese law, I introduced that in accordance with the Chinese law, ad hoc arbitration is not allowed. However, that does mean that ad hoc arbitration is not possible in China. It's possible. What you need to do is that you agreed arbitration in China, but specify the law applicable to the arbitration agreement is the law other than that of the mainland China. For example, Hong Kong law, English law, Swedish law, which permits ad hoc arbitration. Ad hoc arbitration is still possible in China. In the future, I personally think that the law, many Chinese scholars calls for updating of Chinese arbitration law, especially for ad hoc arbitration. It's possible in the future, but at present, I'm not sure. Thank you for the question.
Thank you, Dr. Li Hu.
Okay. Thank you very much. Yeah, I don't know how to handle this. Yeah, thank you very much. So my speech would be a little bit overlap with the Dr. Lee's presentation. So I want to go quickly. So for the part Dr. Lee has already touched. So that's the legal frame of the Chinese law governing all the recognition and enforcement for arbitration award in China. We have a local law plus the judicial interpretation made by Supreme Court, and of course we refer to New York Convention heavily. So, but answer the question. And in China, so we are member of lots of multiple international treaties. So so we have a special regulation in China. The international law prevail the domestic law whenever you have any inconsistency between international law and domestic law. So unlike in many other jurisdictions, so they adopt the international law into their domestic law. So they treat the international law as part of the domestic law. But in China, so the international law prevail domestic law whenever we have inconsistency. Of course, China has built up multiple, quite many bilateral treaties with different countries. And of course, we apply the principle of reciprocity. But these principles be honest, has not yet carried out or implemented in China yet. So there's like one case in the United States, one case in Hamburg. So the foreign court has already, for example, recognized a Chinese court judgment. But generally speaking, as of today, we have never yet recognized any foreign judgment in China. We talk about commercial judgment. We don't talk about the family law judgment or whatever. Jurisdiction. China, we have like a federal legal system. We have Supreme Court, we have the High Court in each province, and we have intermediate court level, intermediate court in each major city, and we have a county level, we have county level and the district level, city level court. So we have this is like a four system, 4 levels: Supreme Court, High Court, Intermediate Court, and the district level court. For most foreign-related matter, including enforcement of foreign arbitration award, you should go with the intermediate level court. That is the measure to assure the quality, because, yeah. So we believe the judges with the intermediate court level court are more professional. Yeah. So you have multiple choice. First, you can go to the court of where the parties are located or where their property is located. So you have multiple choices. So of course, sometimes we talk about the same court, but literally speaking, there's multiple choices. The court of recognition and the court of enforcement shall be the same. So this is a 2-step procedure. The first step is recognition. The second step is enforcement. So within one court, these 2 matters are handled by 2 divisions. One is handled by division, the enforcement division, recognition division. So this division is normally heard about foreign-related matters. And whenever they finish the recognition procedure, they will shift this file to the enforcement division. Be honest, the real problem in China is not about recognition. If you look at the statistics of the Chinese recognition record, so very small percentage of foreign arbitration award has been refused, rejected. Majority of the foreign arbitration award has been recognized. So China, generally speaking, is very friendly to foreign arbitration award. But the biggest problem lies on enforcement. So we will talk about this issue later on. There's a 2 years time limitation to enforce a arbitration award. This is a very strict regulation. So this is based on the new civil procedure law is 2 years. Before, it was half year if both party and company, or 1 year if one of the party is a individual. So 1 year or half year is very short. So one of the cases, so we have a statistic about from 1990 to 2000, we have record of totally 20 cases arbitration award foreign-related arbitration award has been rejected. One of the cases is because they passed the time limitation. But time limitation in most jurisdictions is much longer, like 6 years or 8 years or even longer. But in China, there's only 2 years. So be assured. So you apply to enforce your arbitration award within 2 years limitation. Yeah. The documentation submission requirement is pretty straightforward. We refer to New York Convention. So you need a petition letter, and you need the arbitration award, and you need some documentation to file this case. So you need a business license of the applicant, the power of attorney, if you engage Chinese lawyer or whoever, and you need a letter of authorization. So this is a requirement to file a lawsuit in China. So the first 2 are specified in New York Convention. You need an application letter, so including all the basic information, requires the facts, reasons, and you need attached with the petition letter with the arbitration award. You need to submit original. So we recognize original only. So we need a full translation, Chinese translation. So we need a full translation. And if the materials are made outside China, so the materials must be notarized by notary public. And so we have a different terminology about this process. We call them legalization or authentication. So it's about the same thing. So you need first, notarized. Second, you need the submit a notarized document to the authority in charge of notary public, and eventually you go to the Chinese embassy or Chinese consulate to the country. So this is a pretty long procedure. But in many jurisdictions, like United States or Germany, so people has been used to that. But in some country, this procedure can take some time. The court, whenever they receive this matter, they make a procedural review. If they believe the documentation are in order, and if they believe they have received a Chinese translation, whatever, so they will build up a tribunal with 3 judges to hear the case. Like the other cases, the tribunal is led by 1 judge, and the other 2 just make their comments. They may organize, but not make hearings. Sometimes they call them inquiry meeting. So hearings is more official. Inquiry meeting is about to say, but whatever. So they may or may not take it. If the case is pretty complex, they won't. But if the case is pretty straightforward, they may not have the hearings. Further documentation may be required. That's especially whenever they have debates, challenge raised by the target company. For example, Chinese arbitration system and the court system has lots of difference to the foreign system. For example, one of the fundamental differences about delivery. In most common law jurisdiction, so the delivery was made between the parties. So they don't go through the third party, don't go through the court. But in China, in Chinese court and Chinese arbitration, all the submission between the 2 parties, they need to go through CTAC, generally speaking. But that could be an excuse or reason for the Chinese party to challenge. They may say, oh, we have not received the documentation. Yeah, so we don't receive the arbitration award, we have not received the arbitration notice, we are not given the chance to present the case. We have no opportunity to appoint arbitrator. We don't have a lawyer to present on our behalf. So they may ask, then the court may ask the applicant to submit evidence to prove the documentation, the arbitration notice, or the hearing notice has been properly delivered. So further documentation may be required. And also for example, whenever they challenge the validity of the arbitration agreement, the court may ask you to provide the law of the law you refer to whenever you consider about the validity of the arbitration award. So further documentation would be required. Legally speaking, the court shall make decision within 6 months from the date whenever they accept the case. But it's not a surprise. It's very normal. The 6 months time limitation extended. If the court believe the arbitration award have some defects, if they have some willingness to reject or refuse to recognize the arbitration award, they should apply for approval or consent from the higher level court. This is a very unique system. We call them internal review procedure. This procedure was purposely established to guarantee, because only the higher level, if you want to reject the arbitration award, you need consent from the upper level court. If the upper level court agreed to reject the arbitration award, they should apply a further a level agreement, consent from the upper level. So eventually, the decision of refusal can only be issued by Supreme Court. So that's the way the Chinese legal system guarantee. So they don't give the lower level court the authority to reject arbitration award, foreign arbitration award. Only Supreme Court has such power. That's why we say Chinese court is pretty friendly to foreign arbitration award. Whenever we say the Chinese court decision is pretty consistent, that was because the only decision maker to reject arbitration award is Supreme Court. And that policy has been applied over years. It seems like works pretty well. I specify some main reasons. All these reasons are specified in the New York Convention and the Chinese law. So for the reasons to reject, to refuse arbitration award, foreign arbitration award, so that's fundamental reasons. It's basically the same to what has been stipulated in the New York Conventions. Yeah, that's a statistic. So we had for the cases, refused cases from 2000 to 2010, because the only decision authority is Supreme Court. So that's the figures was given by a study report by a judge from Supreme Court. So they specified all the reasons. We can see for most refusal cases, the reason was there's no arbitration agreement. But that mean a lot. So normally, an arbitration, there's two cases, maybe three cases. So whenever the parties go to arbitration, they refer to the email exchange. The agreement, the order itself does not include arbitration agreement, but they have some hints, they have some discussion about arbitration via emails made after the contract. So the question is whether the email can constitute a joint consent. So that's debatable. The major reason is the improper arbitration procedures. That was basically, it's about procedure. So students, if you don't are familiar with the arbitration, so the judicial review of the arbitration award based on the New York Convention, you should focus on the procedure issue only. You don't touch the merits of the case. It doesn't matter it's a right decision or wrong decision. It doesn't matter the interpretation of the law is right or wrong. It's about whether the procedure has some defects. So everything is about the judicial review is about whether you have any procedural defects. So all the reasons relates the procedure, whether you have whether you have a valid arbitration agreement, whether the tribunal was built up properly, whether the party has been given proper chance to defend themselves, whether they are noticed. Yeah, so all this is just about the procedure issues. So the only exception would be the public interest. By far, as of today, there's only one case. So the Chinese court refused the arbitration award, foreign arbitration award, with reference to public policies, as we talked about Minister before. As we said, the real problem in China is not about recognition of arbitration award. It's about enforcement of arbitration award, or not only about enforcement of foreign arbitration award, but the enforcement of Chinese court judgment, enforcement of Chinese arbitration award has similar problem. So the first excuse would be, for example, they say, enforcement would cause the insolvency of the company, so we don't have money, or otherwise you may cause a loss of unemployment, that may cause a loss of problem or chaos. So many reasons are not legitimate in foreign jurisdiction, in many other major jurisdiction, but could be, make sense in China. So because we are a developing country, so employment is very important, tax important, local protectionism exists for whatever the reason. So enforcement would be a problem. We saw lots of improvement, but as of today, it's still a problem. The result of, during the enforcement, it's not a surprise that the target company come back to you again for a deal. They say, I know I should pay you such amount, X amount, but because whatever the reason, so what about I pay you 80%, 50%? So it's very popular in China. So during the enforcement procedure, so the parties come back for a deal, for a discount. It's pretty popular. The period of enforcement is unlimited, so it can take very long time. Particularly if we talk about a big amount, particularly if we talk about real estate or transfer of real estate, or we talk about if the target company is state-owned company, they have good connection with the local government, whatever. So that's a very brief introduction about the procedural requirements. So which court you have to go, so what documentation you have to submit, so what whether we have hearings, so what the reasons you may confront for the refusal. So I gave a very brief introduction about the. I can see. Okay.
Thank you very much, Mr. Meng. Just before we open to questions from the floor, I have one question which I would pose to either of our speakers so far, which is about the concept of sovereign immunity in China, because one of the issues which parties often face with enforcement when it comes to a state entity, and certainly an organ of the state, is that they rely on immunity. And whilst much of the world has moved towards the concept of restrictive state immunity, which distinguishes between those acts which a state performs which are commercial and does not attach immunity to that. It was my understanding, which of course may be incorrect, that China goes with an absolute immunity. And there was a decision, I think, of the Hong Kong courts last year in FC Hemisphere and the Congo, where they further said that in order for a waiver of immunity to be effective, it would have to take place after the dispute had arisen. I wondered whether you could confirm if my understanding is correct.
Yeah, that's right. So whenever China become a member of the New York Convention, we have a very clear reservation about this. So not only these, if you study the other international treaties, you can always find China will always have such a similar type of reservation. So we don't, for example, we don't want to submit the disputes if the party is government to any international arbitration. No, we don't want Chinese government to present before international arbitration. So yeah, that's always the. So as of today, we don't give up. We give up the. Yeah.
And how far does that immunity extend under Chinese law? So. Obviously, an organ of state would be covered, but what about state-owned enterprises, for example? Would they?
State-owned company, legally speaking, they are treated as a normal entity. But this issue could be abused because, like, for example, 20 years ago, 30 years ago, so there's a New York case, very famous. So they file against Bank of China. So they believe Bank of China is a state-owned company. So the U.S. court say, oh, if you're owned by the state, so we can enforce the asset of other state-owned company. Yeah, so that's happened. So China become very sensitive about this issue. So, but literally speaking, state-owned company are treated equally to other for FIE or domestic or private company.
Thank you. So, any questions from the audience?
Thank you. Concerning about the table you have showed to us about the refused cases from 2000 to 2010, I want to ask where this date came from. Is this in the if this came from the mainland court, mainland China court, or from the CTAC in Hong Kong?
We talk about these figures came from the a study report made by a Supreme Court judge, because all the go back to Dr. Lee. So whenever we talk about the foreign related matters, so normally we talk about three types of cases. First is foreign arbitration award. The second is foreign-related matter, foreign-related. For example, a case judged by CTAC where one party is Chinese party, one other party is a foreign party. So foreign arbitration award, foreign-related matter. And the third is the arbitration award made in Hong Kong or made in Taiwan. So all these three types of awards, if the court want to refuse, they need report to the higher level and eventually to Supreme Court level. So why we say this is pretty powerful is because this report was done by Supreme Court, because they are the only decision maker for recognition. Yeah, so that figure is pretty powerful, pretty accurate. Yeah, but of course, covering both the foreign arbitration award as well as foreign related matter judged by Chinese arbitration authority.
If in the contract the opposite party has ruled the arbitration clause, if this arbitration clause is a multi-tier arbitration clause, and as concerning about the table you have shown us about the reduced cases from 2000 to 2010,
Yeah.
there is one reason that in proper arbitration procedure rights, if this multi-tier arbitration clause has ruled
to the improper arbitration procedure?
Yeah, so the New York Convention have only gave like some major reasons. So I think why we specify in the breakdown like these is for easy understanding. But of course, you can say basically it's about procedural defects. So the yeah, so that's the reason given by the author of the research report. I be honest, I don't know which case he referred to. I know most of the cases, but I don't know which specific case she referred to. Yeah.
I just want to know if the multi-tier arbitration clause, because it is actually has rules the prerequisites before condition before the arbitration. Yes, this can be identified into this kind of can be a refusal reason, that is the improper arbitration procedure. This can be said that or can be ruled in it.
So if you can help to reorganize the question would be helpful.
Actually, she talked about one special, a kind of special arbitration agreement.
Okay.
The parties agreed to arbitration, but they agreed pre-condition. The parties should negotiate at first. If a negotiation fails, one party may
Okay.
apply for arbitration.
That is a famous case, but okay, it doesn't matter if it's about it. The background was like this. So we tell the truth and we say why we mean. So generally speaking, whenever we have a contract, we always say, so whenever a party have a dispute, they should have an amicable negotiation before they file the arbitration award. This is very typical. So normally, if one party, for example, they ignore this negotiation requirement, if they go to arbitration directly, it's fine. So generally speaking, worldwide. So they don't necessarily take negotiation before the arbitration award. But for this case, I think you talk about Pepsi case. So that's very sensitive. So that refers to some very complex background. So in that case, the court say, in this agreement, the agreement specify there is a 45 days negotiation or 60 days, I forgot, either 45 days, 60 days. So the court said, no, because you did not complete you didn't carry out negotiation within the 45 days. You filed the arbitration directly. So that's a very technical. But the background was more complex. It's about some. So yeah, Dr. Lee know better than I. So but yeah, I would say this is a exception. This is not a strong reference. So if parties fail to take negotiation before filing the arbitration, it should be fine. But this case is pretty unique, very unique. If we talk about this Pepsi's case, if they fail to, so that's a exception, total exception.
Well, at CCHEC practice, when we accept cases, we often see such arbitration clause stipulating the precondition for arbitration. So we decide the question, we see whether or not such precondition is mandatory to the parties. For example, the parties shall negotiate within 45 days. You must demonstrate such precondition has been met before you apply for arbitration. When you apply for it.
Another interesting case is like this. The tribunal should be made by 3 people, but during the arbitration, whenever they finish the first hearing, one of the arbitrator, for whatever the reason, he was not able to participate the following procedure. He was arrested. So he did not participate the following discussion among the arbitrators. he did not raise his opinion whenever the draft arbitration award is made, because the procedure is like this. Whenever the chairman is always responsible for drafting the arbitration award. So whenever he or she finish the draft, he should circulate the draft to other members for their comments, for their discussion. So, but because one of the member was arrested, he was not able to raise his comments. So the remaining two arbitrators conclude the arbitration award. So that's one of the cases I referred in this statistic. So before Chinese court, that's a challenge. The losing party say, I'm sorry, because the arbitrator we appointed, he was arrested. He did not participate in the following procedure. He did not have a chance to review our documentation. He did not participate the discussion among the tribunals. He did not raise his comments to the draft arbitration award. So we were not given opportunity to appoint a new arbitrator. So that's the defect. That's a procedure defect. That should be a reason to reject the arbitration award. And that's the claim of the loser was recognized, upheld by the Chinese court. So Chinese court believe, so it's not a majority. This is not a normal so-called majority award. Majority award means 2 prevail 1. So the 2 make a award. So the other party, the third arbitrator has some disagreement, but his disagreement could be, of course, put in record. But this case is not a default. This is not a majority award. So the loser should be given an opportunity to appoint a new arbitrator, because the comments, the opinion of the third arbitrator, the arbitrator of the loser, may have some influential, may cause some impact to the decision. So the loser was not given opportunity to appoint a new. So that is a typical situation whenever I talk about the party was not given proper opportunity to present themselves. So so normally they refer you are not given the time opportunity to engage a lawyer. You are not given the proper time or notice to present the hearing, and very important, you are not given the opportunity to appoint arbitrator. Arbitrator plays a very crucial roles. I can give you some examples.
Thank you. Just again, in the interest of time, I think we'll take with one last question before we move on to our final speaker. Thank you.
I have further question about the the period negotiations. My question is, as you mentioned, the 45 days of the 45 days case, and is a negotiation period, and it became the preconditions before the arbitration can commence. And my question is, if the negotiation period comes to 1 year, 12 months, is it still binding? Because in the practice, if the negotiation time is very long, is it still binding for the both parties?
Well, good question. I never seen a contract to provide a negotiation period for 12 months. That's very hypothetical. But I never seen that one.
I personally think as if the arbitration clause says the parties, after disputes arise, the parties may negotiate within 45 days or within 1 year. It doesn't matter. You can apply for arbitration directly to the arbitration institutions.
So the negotiation period is not the essential element of the precondition?
It depends on word. If parties shall negotiate, if parties may negotiate, doesn't matter. It's different.
If it is shall negotiation, so it is binding?
Yeah, you must demonstrate that precondition has been met. The period, only period expires, you can apply for arbitration.
Just to some supplements for her question, is that if the precondition, the exact rule is that the parties shall have a 12-month period of negotiation before, and after that, the parties may submit the case to the tribunal. Is this still a binding arbitration clause, because it used shall for negotiation and used may for
arbitration?
So question is
You mentioned that.
whether or not the precondition mandatory to the parties.
Yeah.
If it's not, you can apply for arbitration
And
directly.
whether this is still a valid arbitration agreement because the parties may submit it to the tribunal and it used shall.
I
for
think it's a
arbitration.
valid arbitration agreement.
Yes.
Yeah, you know, it depends on the law applicable to the arbitration agreement. If decides the validity of such arbitration agreement in accordance with Chinese law, it's valid. Of course, it's valid. It's valid. It contains contents for arbitration.
Yeah, but of course, if I'm the arbitrator, first I want, of course, to confirm the validity of the arbitration agreement. If coincidentally Chinese law applies, so I have more confidence to make judgment. I would say, if we reasonably believe the party cannot make a agreement, amicable settlement agreement between them, no matter how hard they work on. So I think the 1 year is not binding upon this because But I would say the parties should convince they have tried very hard. They make real efforts to try to reach a settlement agreement. But if I reasonably believe there's hopeless, it's hopeless to make a agreement. I don't necessarily wait until the 1 year expires. So I would say fine. So you can file this case, but only if you convince me. So it's hopeless after reasonable try. So I don't necessarily bind upon by the 1 year period.
Well, thank you very much, Mr. Meng. So I'll give the floor now to Rostya Pekash.
Thank you very much. I will break with the tradition of speakers standing, and I will remain seated. And I hope that this will actually invite you to interrupt me with your questions as I speak. Because the topic of my presentation, and I would rather call it the topic of my speech, because I'm not presenting any slides, as you have noticed, is practical problems that you may encounter with enforcement of arbitration awards. And I cannot resist the temptation, actually, to start by answering your question in the context of investment law, because this will illustrate the sort of two views that have been presented by my two co-panelists. I don't know if you are familiar with investment agreements, bilateral investment agreements, where countries basically agree to grant certain protections to investments made by nationals of the other contracting party. Those are, I would say, interesting agreements because they allow the investors to bring their claims that the host country has violated the investment protections granted under those agreements in international arbitration fora. It may be under the Washington Convention, that it would be ICSID in Washington in this case, but it can also be ad hoc tribunals under the UNCITRAL rules, or potentially ICC tribunals in Paris, or Stockholm Chamber of Commerce tribunals in Stockholm. Very typically, those arbitration clauses actually say that any dispute between the investor and the host country must be negotiated amicably for a period of 6 months. So it's not as long as 12 months, but 6 months is nonetheless a pretty long period. And the investors often complain that during those 6 months, many bad things may happen to their investments. So for them, this sometimes is a problem, actually, to comply with those periods. Another reason which is raised in support of what we would call the skipping of the negotiation period is that, exactly as it was said here, it is absolutely obvious from the very beginning that no settlement is possible. This may arise, for instance, in a situation where the investment is hurt by a change in the legislation of the host country. because here we deal with the separation of powers. If the parliament passes a certain law, it is extremely difficult then for the executive branch of the government, which deals with the investment claim, to come and say, we actually think that this law violates our country's international obligations, and therefore we are willing to settle the case, and we are willing either to insulate the investment from the effect of the law, or we are willing to pay monetary compensation. This is, I submit, it's not realistic to expect any executive branch of the government to take such position, because they would be immediately sanctioned by the parliament. The parliament simply wants to enforce the laws that they pass. So when the issue was submitted to arbitration, and it arises very often that the investor starts the arbitration prematurely, before the lapse of the mandatory negotiation period, the tribunals have to decide on the issue. And it's quite amazing to see that the jurisprudence evolved. At, let's say, 10, 15 years ago, when investment arbitration started, the negotiation requirement was disregarded by almost every single well, not almost, but by every single tribunal. And there were various theories offered to support the decision that actually the negotiation period can be skipped. The most important one, maybe, was the theory of futility. The arbitration tribunal said, it was futile to negotiate in those conditions because of the specific conditions of the case. And also some tribunals said we would find it very odd sitting now at the hearing, which often takes place, 1 year, 1 year and a half after the arbitration started, to say that we don't have jurisdiction because 1 year, 2 years ago, the investor should have waited, 2, 3, 4, 5 months more in the hope that the investor would be able to reach a settlement. We saw that in real life there was no settlement reached within 2 years. So why should we now send the investor home and maybe ask the investor to wait the 2 months and then redo the entire process? It's certainly not in accordance with the basic principle of procedural economy, which is one of the guiding principles of arbitration, and that's why parties go to arbitration as opposed to courts. So that was the prevailing thinking during many, many years. And then, especially in some Latin American cases at the very beginning, when the host countries started actually to leave the Washington Convention system, arbitrators thought that, after all, those negotiation provisions maybe do have some meaning. Maybe it is important for a country to have an opportunity to negotiate. Maybe it's not nice for an investor to skip it altogether. And they started to enforce it. And even though I would say that even as of today, the decisions enforcing the negotiation period, so decisions which were taken 2 years after the arbitration started, and decisions telling the investor, we are terribly sorry, but we have to dismiss your case for lack of jurisdiction because you filed it too early. No, please go back, comply with the negotiation period, and then you may come back. It's a very harsh decision because it basically means that the investor has just wasted millions of US dollars on their counsel, and probably also the investor will now have to pay the costs of the state, which was successful with its defense. So it was a very costly decision to skip the negotiation period. So even though the decision has those very harsh impacts, they say, guys, we have to comply with what is written in the treaties. And I would say, and Matthew, I would also like to hear your views on that, the fact that 1, 2, 3, 4 of those decisions were issued has led to the fact that now counsel always advise clients, please do comply with the 6-month period, because you are taking an enormous risk, even though personally we would not always agree with the idea that it should be decided this way. This creates such a risk for the investor that it's always better for the investor to comply with it and then go to arbitration and have the certainty that he will not be asked to redo the entire way when he is 2-3 years into the procedure already.
I think that's exactly right. And just sort of to illustrate the point that Rosti was making, I represented Deutsche Bank in a claim against Sri Lanka, an ICSID claim that started in 2008, and it concerned certain actions of the Supreme Court and the Central Bank in Sri Lanka, which we said were in breach of the Germany-Sri Lanka BIT. Now, we started that claim after, I think, two months after notifying the government, even though the treaty had a 6-month cooling-off period. We did so because we were reasonably confident that, based on the case law at the time, the tribunal would not hold us to that cooling-off period, because the vast majority of cases then had not done so. And in fact, Sri Lanka, which was represented by the eminent Professor Crawford, didn't even raise this as a jurisdictional objection. It wasn't even raised. And I suggest that today the same objection would certainly be raised and would have a much better chance of success. And I think as a result, I would always advise investors, unless there's an absolutely compelling reason, that the safest route is, of course, to observe the cooling off period.
Thank you. So now I will revert to the main theme of my speech, which is what can go wrong with the enforcement. I have to say that I believe that many problems with enforcement actually are created at the moment when the arbitration clause is drafted. And I take the opportunity of having young lawyers in front of me, and young lawyers who probably will not do arbitration all, and some of you will be excellent corporate lawyers. And if I may beg your attention, I would say, for this issue, please do pay attention to it. What we see very often is that arbitration clauses are taken from another contract, with a completely different party, with a completely subject matter, and without any consideration for where the arbitration award might be enforced at the very end. And this is a big problem, because you heard here how important, for instance, the law of the seat of the arbitration is, because this may be absent a specific agreement of the parties. This is the law which will govern many procedural issues. This is, for instance, the law which will govern the validity of the arbitration clause. Very often parties fix the place of arbitration based on what they saw as a good choice, somewhere in another contract. What they think is a good place to arbitrate in, because of good flight connections, for instance. And they don't realize that they are making important legal determinations because they subject their agreement to one specific governing law, which may provide things that they don't know of, and they will be very surprised when they see the operation of it. So, for example, in Switzerland, there is the doctrine of non-signatories to an arbitration clause, which is quite surprising for many other countries. But in Switzerland, the requirement of the existence of a written arbitration clause or a written arbitration agreement is something which is interpreted as, okay, we have to have it in writing, but it does not necessarily have to be signed by the parties which are bound by it. In Switzerland, the arbitration tribunal has the power to determine who is bound by this written text on the basis of all the relevant facts. So it's not only about who signed it, it may also be, what other parties seemed to somehow be associated to the agreement in question, for instance, and then they would say, fine, we would extend the arbitration clause to those parties as well. So we can imagine a situation where, someone agrees to arbitration in Switzerland, and then is very much surprised that it's not only the company which signed the agreement, but also its sister company or its parent company, which may be found to be bound by the arbitration agreement, and there will be an arbitration decision issued against them in Switzerland. Which, however, now leads us to a different question, which is more closely related to enforcement. Will such arbitration award be enforceable elsewhere, outside of Switzerland? Because we know that the New York Convention says that one of the pieces that must be produced in order to obtain enforcement is the original or a certified copy of the arbitration agreement. Will a Chinese court be convinced by the reasoning in the award, which says, okay, company X did not sign the agreement, but we think it's bound by it, therefore we arbitrated, and we condemned company B to pay some amount of money? That's actually a question that you may want to answer later on.
So that's also, you can refer to called like a group company doctrine. So I gave some illustration about this case. So this is referred to like a Dow Chemical. Dow Chemical is a very famous company. So whenever the contract was signed, this contract was signed by Dow Chemistry, an office in France. So the subsidiary of Dow Chemical, the Dow Chemical is based in the United States, but the contract was signed by a subsidiary of Dow Chemical. But the terms of the agreement was determined by Dow Chemical United States. The contract was carried out by the people from United States, and everything was done. The payment was made by the Dow Chemical. So the one arbitration award made by ICC, this is an ICC case. So I gave some support about this. Whether it's possible to include some non-signatory into the picture. So the ICC award confirmed that, Dow Chemical United States, you are binding upon by this agreement, because from the time whenever the agreement was concluded, during the performance of the contract and taking into consideration of all the aspects, we believe you are the party to enforce this agreement. So you are subject to this. So of course, the court in Paris support these ICC awards. So that's make a good reference to the case. Chinese court. So we begin to accept all these international doctrines. For example, the most recent amendment to Chinese company law, we accept the piercing the corporate veil theory. So all this theory is trying to find the controlling person or the party behind the person, the company signing the contract. So we made some progress. So that's the background why Chinese court. So we support. I think, yeah. So that's background. And also Chinese court is very friendly, basically very friendly for foreign arbitration world. But this type of situation is still challenging. So be careful.
Yeah. Well, I think that there are many countries where the courts would not recognize it, and I'm afraid that the Czech Republic would be one of them, because our interpretations of the law tend to be quite formalistic. I can give you another example, actually, which relates to the Czech Republic, and I don't have the ultimate decision yet because it relates to a pending case. But there is a case where actually the party which won an arbitration is not able to present the original of the arbitration clause. There's no dispute between the parties that actually the arbitration clause exists, and it was not raised by the other party in the arbitration that there is no arbitration agreement. It's a purely formalistic situation, which arises probably because the agreement dates from the beginning of 1990s, and the winner probably does not have very good archiving service. So they are not able to find the original, and the Czech courts have been struggling with the case for several years now because they just don't have the original, and the New York Convention says that they must have the original. Another problem that actually was mentioned already is that today some agreements, and that goes back to the original point actually, are concluded by email. There's an email exchange of documents, PDFs, sign it, never any original exists, actually, because both parties have the PDF. In most countries, that's enough, actually, to, let's say, arbitrate based on it. But there are countries where it's not enough, then, to enforce under the New York Convention. And that actually brings me to the point, which is important for those who draft arbitration clauses. Normally, if you know that you are likely to enforce in a certain country, because all the assets of the company are located in that country, you should seriously consider placing the arbitration in that country. Because then the enforcement will not be done under the New York Convention. It will be done under domestic laws of the country, which usually are simpler, because the New York Convention may present an additional hurdle, actually, to it. And now I go back to another point, which is how the courts in practice implement the New York Convention, at least here in the Czech Republic. My experience is that they say they actually implement the New York Convention, but in fact they implement the domestic law on arbitration awards. And they just tend to interpret anything which is written in the New York Convention as, you know, providing for the same things that they know better, let's say, from their domestic law. Now I was asked to address a very thorny topic of what public policy is. And I think it goes, it is the right time to do that. I would say that in principle I do not know what public policy is. Or a very cynical answer would be that public policy is a sort of carte blanche for the court to refuse enforcement when the court feels that the enforcement should be refused. This is too cynical, I think. As lawyers, we should be able to come up with a better explanation. But it's true that there are countries where public policies tend to differ a bit depending on the company against which enforcement is sought. Especially if the company is somehow related to the state, then there may be many public policy problems with the enforcement of the award, especially in Latin America. I invite all of you to go and try to enforce an international arbitration award, for instance, in Venezuela against their state-owned oil company. You will see many public policy reasons, you know, popping up, many problems actually with the arbitration procedure and so on. So this is, as I said, a very cynical view, which also leads me to something that I might, I think, tell you as a sort of advice. It's always easier to enforce an award against a company outside of its home country, because third states usually don't care so much. And that's also which is frequently used against this state-owned Venezuelan oil company, because they have operations abroad. So parties normally, when they want to do something against them, they try to do that in those third countries. They want to attach the assets there.
Yeah, if I can give an example about a Hong Kong court judgment, very recently, 2012, they made a decision with regard to public policy. Yeah, public policy, so we can also use some other terminology like public interest or public orders, means about the same. So the case is a arbitration made by Xi'an as a local arbitration institute in 2010, probably. So the background was like this, pretty simple. The tribunal was made up by 2 Beijing arbitrator and 1 Xi'an arbitrator. By 3 people, 1 Xi'an, 2 Beijing. So after the first hearing, the parties agreeable for a negotiation for whatever the reason. They say, oh, we don't want to spend time on this. Yeah, we are fine for negotiation. So the tribunal say, the 2 Beijing arbitrators say, oh, we left, we go back to Beijing. So what about the third arbitrator, Xi'an arbitrator, please? So you in charge of this arbitration. So we use the word preside. So please preside negotiations. We leave to Beijing. If successful, fine, notice us. Otherwise, we resume the procedure. So the 2 Beijing arbitrator left. So the third Xi'an arbitrator, he invited the Xi'an arbitration general secretary. So he said, we need a person help us. So what about the general secretary of Xi'an arbitration? So you help us. So they received the consent from other 2 Beijing arbitrators. So according to the rules, it's fine. So the negotiation right now charged by two Xi'an people. One is a member of arbitration tribunal. The other one is general secretary of Xi'an Arbitration Commission. That's first issue. So they include a member who are not a tribunal member. That's first issue. Second issue, more ironically. So the arbitration was taken in March 27th, 2009. So very good day. So they invite the party who may lost this case, not the lawyer, not the equity owner, but a so-called a close friend of the party, who did not participate in the hearing before, but they believe, oh, he is powerful, he may cause some influence. So he include this party to Shangri-La Hotel, and they have a wonderful dinner with these three people. So the negotiation was taking place at a dinner. That's the truth. So that's Chinese style. The negotiation at a dinner, very wonderful dinner, and this dinner was paid by the close friend of one party. But the settlement was failed. So they could not make a settlement. So the arbitration procedure resumed. So the party was charged to pay some money. So that's the background. This is a Hong Kong company. The loser is a Hong Kong company. So first, the party, they filed a lawsuit within the Chinese court because the arbitration was in China, in Xi'an. So the first reaction, of course, they try to overrule these arbitration award with the court of where the arbitration is made. So, of course, Chinese court, they support the arbitration agreement, award. So the loser eventually raised a claim with the Hong Kong court. Two levels. The first level, the court judge is a British guy. So he said, oh, I have two concerns. The first concern is, so whether there exists so-called apparent BAs. Apparent BAs is, for example, look at these negotiation. So they include a party who are not a member of the tribunal, and who is the chief secretary of Xi'an Arbitration, the arbitration body. He's very powerful. So I got a feeling this is a negotiation is not handled by tribunal, but by some person outside the tribunal. And second, look at the manner of the negotiation in the table. Very unprofessional, very unprofessional. So that's the question whether there is a apparent BAs. Second concern is whether enforcement of such award will cause any public policy concern. So he believes this is a really challenge, conflict to the core value of Hong Kong legal system. If we recognize, enforce a award, conclude in a manner like this, that's weird. So the superior court, first level court, reject this award. But however, the appellate court confirm this award. They say, okay, for first two issue, apparent BAs, they say, okay, yes, the conciliation, mediation was conducted in the manner we don't feel comfortable. We're not used to. But however, it seems like they comply with Chinese law. For example, the arbitration rule. The arbitration rules allow, with the consent of the tribunal, you can invite a third party, some party outside the tribunal, to participate. It's fine. So literally speaking, nothing wrong to have the general secretary to involve this case. Nothing wrong, and nothing to show. So the decision is made by the final decision is made by the secretary in general. So that's the second, very confirmative. They say we don't believe recognition and enforcement of a award like such will cause any undermine the Hong Kong legal system or cause any public policy concern. So that's another case relates. So that means even a conciliation was handled in a way like such. So and in Hong Kong, as of 2012, this is not a legitimate reason you refer to public policy to overrule a award. Yeah, so that's a very recent case happening in Hong Kong.
Yeah. Thank you. Really, I think public policy, obviously, is not a carte blanche to the tribunals to decide whatever they want. But it's a way for them to basically say, we think there are certain rules which are fundamental, certain things which should not be taking place in our country. And there is an inherent tension between this and the fact that the arbitration took place abroad, where the perception is different and where things are accepted. And now there's a tension between, on the one hand, I would say, legitimate interest of the country not to recognize certain foreign practices, or think that's, for instance, like in China, that a foreign arbitration tribunal should not have the power to effectively overrule a decision of a Chinese court. And on the other hand, the rules of comity would say, okay, we have to respect the fact that this is a foreign award. We understand it would have happened differently in our country, but the parties chose to arbitrate somewhere else. It was okay somewhere else. So is it a reason for us to refuse enforcement or not? And this is an open-ended question, and that's why there is no binding definition of public policy. All laws in the world just say public policy is one of the reasons for refusal, and it's for the courts to find what public policy is. And obviously, what they find public policy is also evolves in time. What I referred to before when I was speaking about Latin American countries, it was more of the abuses, obviously, of this notion, which are very important, though, and must be taken into account as well. There's one final issue that I would like to share some thoughts about with you, and that's the fact that normally when those procedural irregularities, for instance, happen, the usual remedy is not so much to resist enforcement only, but also to ask for the setting aside of the award in the country where the award was rendered. This is an opportunity that this should be the first remedy because, okay, something bad happens, the law of the seat says it should not happen this way, and if it happens, then the court may intervene and annul or cancel or set aside the award. And that's what may happen more or less often. But there is one important caveat to that. There are certain countries in the world which would be willing to enforce an arbitration award even though it was set aside in the country where it was issued. And this actually is permitted under the New York Convention, because if you read the New York Convention says that enforcement may be refused if the award was set aside in the country where it was issued, which also means that it's not an obligation. It may be enforced as well. It's up to the court to decide. And here, I would take the question immediately. A country which is quite famous for doing that very voluntarily is France. And that's important. That's an important country. Many companies may have assets in France, and those assets are then, under a greater risk, let's say, of enforcement, because even if you have arbitration in a country that has rather stricter approaches to what is permitted in arbitration, and something not so compliant happens in the arbitration, you may be able to obtain the setting aside of the award in that country. But then the other party can go and move for enforcement in France nonetheless. France is, I would say, extremely supportive of arbitration, among others because Paris is one of the major arbitration hubs, so it's good business for French lawyers, obviously, and the state understands and supports it. So the assets in France, may be threatened by this kind of situation. So if a company has assets in France, actually, and then consents to arbitration, the company should understand that the arbitration rules, let's say, will be interpreted rather liberally in France, and has to accept this specific feature, let's say, of French law. And the reason why the French do so is that they say, obviously, we live in a material world, so the arbitration tribunal has to sit somewhere. But in fact, the world of arbitration is an ideal world of ideas. And the fact that the arbitration is set somewhere should not prevent French courts from assessing the issues. It was just an incidental link to some country, And we don't care so much about that because we French judges know the best. But I will not submit any further comments on the French attitudes because it's probably not reserved to arbitration. But anyway, there was a question there.
Thank you. First, to the French opinion, I believe that at least according to Professor Vandenberg commentary, it's not really based on the first sentence of Article 5, the May word, but it will be based on Article 7 of the New York Convention. Actually, that is a way how they introduce their doctrine to from the national law into the New York Convention. But it can be just his opinion. I haven't read the decisions because it's in French. But I had a remark to what do you think of the UCOS group cases in the Netherlands, where they did the same thing, that they refused to, that they actually enforced a vote which was set aside in Russia, and there it was based on the idea that in order to actually refuse enforcement, the decision to set aside has to be recognized itself based on the private international law in the place of the enforcement court, and that's where they based it on. They said that recognition of such annulment decision would be against public interest, and thus they decided to enforce the award anyway. I believe it's important to know that this decision was in case of Mr. Khodorkovsky, who was trying to actually get back to at least some of his assets in Russia, where he was deprived of them by the Putin administration.
Well, as to the first remark, Professor Gaillard, who is the leading authority, I would say, in France on this very liberal and abstract approach to arbitration, I think he calls it the transnational arbitration order or something like that, has written a book on it. And because he wants his ideas to be well known, actually, he arranged with his editor to make this book cheap. And when people were asking him, how come that the book is so cheap, because you may have noticed that arbitration books normally are pretty expensive, he said, well, that's because I want everybody to read my books and understand my theories and so on. So if you want to know, let's say, more about that, you may read the book and you will, I think, understand his idea. I must admit, I did not read the book. I know that none of Czech judges would read the book. And so I think that Article 5 and the May is probably what, in practice, determines the issue. And here I agree that the theory is much more complicated and better crafted than I presented it. That was a simplification, but I like to make simplifications because I think they are more funny and they are easier to remember than the actual. And then when it comes to UCOS, I think there are some situations where we have to understand that politics take over law. And it's the case as well, in Russia, in the annulment decision. But I would also submit that was the case also in the Netherlands, in the refusal to sort of give effect to the setting aside decision. So, you can always find a legal theory which will explain why something was done. But I think that when it comes to UCOS, decisions are made on political grounds much more than legal grounds, and then the legal theory has to follow. And to tell you something not so nice for the law, again, is I once participated in a discussion with a leading arbitrator, and he said, please don't believe for a second that arbitration tribunals decide on the basis of the law. The law is there to provide justification for the way we decide, but that's completely different. When we decide complex cases, we understand that, by definition, we are in situations where it's a very close call. It can go either way. Obviously what I say now does not apply to some non-payment of debts or whatever, but there may be very complex disputes. And what he said very openly, I will not name him, but I would assume that every member of the arbitration community knows him. He says, well, if it's such a close call, we decide usually by the credibility of witnesses. And if we think, because we think that the party which sort of is right, and it may be morally more than legally, actually will have witnesses which will be able to present things, and then, you know, we will understand that those are the, if not the good guys, then at least the better guys than the others. And we will decide in their favor, and then we will look into the law, which will show us the way how we can justify our decision. But the law is not the thing which leads us to the decision. We make the decision on something on a different basis, and then we use the law as the way which leads us to the award.
Just one point to add to the sort of idea of countries which overstep the mark and resisting enforcement by way of public policy exceptions. There is also another way which countries can sort of overstep boundaries, which is not strictly related to enforcement, but actually involves taking supervisory jurisdiction over an arbitration which was seated elsewhere. And that has a jurisdiction that was particularly famous, or rather infamous for that, was India, where the courts had on more than one occasion assumed a supervisory jurisdiction, and therefore the jurisdiction to review and set aside a foreign-seated award because they deemed that the arbitration still had sufficient connection with India to fall within Part 1 of their Arbitration Act. I'm pleased to say that is sort of an exception rather than a rule, but it's nonetheless an important one. And actually there have been some encouraging signs recently from the Indian courts. I saw a decision just a few weeks ago from the Reliance, BG Reliance and India case, but it is not. There's more than one way to frustrate an award, I think, is the bottom line. Well, I'm looking at the clock. I think we've run for almost exactly 2 hours, which is what we planned by accident as much as by design. But I think that unless there are any burning final questions, I will allow the no doubt tired co-panelists to retire, and thank the audience very much for your very active participation, which has made it a very enjoyable experience from this side of the room, at least. Thank you all.
Yeah, thank you.